Are you ready?
Give me 1 minute, please.
Miss you. Oh, hi, come on up. Hi. Hi, nice meeting you. Sure.
No, you're good. It was kind of funny.
Yes. But hey, so what are you planning on doing? Are you just shadowing to see? Mhm. Okay. Awesome. Mhm. Yeah. Mhm. Mhm. Okay. Yeah, and then you're always welcome to come here anytime. And we should have a jury selection tomorrow. Yes. Oh, we do it. Jury selection in the afternoon. And then on Wednesday, we'll have all-day trial. No. My mom always says, where you work, you should make sure
I forgot to
that
I'm trying really hard
it's
to get
as
them.
beautiful as it can be, because other than home, the most time you spend is at work. So, yeah. Oh, yeah, put some flowers up, and they're so inexpensive. Yeah. They do. Yeah.
Yeah.
I'm not sure. Yeah. Yeah. But yeah, just have a seat wherever, and then you can introduce her to Bashan, the probation officer. Yeah. And if you, do you want to go to the back to see the back?
I think I'm done. I said everything is.
The back?
For what I could say. I get with it.
All right. Deputy Mejia, do you have time to show her? All right, court is calling 2022 CR 11862, State of Texas versus Alexander Castro. Can I have parties announced for the record for the state,
Daniel Escobar and Jason Garahan for the state of Texas.
for the defense?
Jasmine Olguin, Your Honor, and I would like for Mr. Jason Goss to be able to join the trial. We're requesting that with the court. Mr. Hillier is not present, as previously made aware of the court. He had to go out of the country.
All right, so he left to go on vacation. And so that the record can be clear, this was the date that parties chose. With regards to Mr. Goss sitting there, he hasn't been qualified for the jury. State, do you have any objections to him sitting?
Yes, Your Honor, the state objects to Mr. Goss sitting.
Your Honor, may I respond to that? I am his counsel of record. I have been entered as his counsel of record, and the state's right to not have me sit there does not supersede his constitutional right to have counsel and effective assistance of counsel, including counsel of his choice. Also,
Why are you not here in the beginning during jury selection if you are his counsel of record?
Your Honor, I, along with Jay Norton, Nico LaHood, Patrick Ballantyne, Jasmine Olguin, and Gary Hillier are all his counsels of record who have entered a notice of
My
appearance.
question is, why were you not present during jury selection? This is the first time that you have been a part of this jury trial. So my question is, why were you not present during jury selection? Why have you not been present during the state's case in chief? Why are you just now making an appearance?
Yes, Your Honor. I had other matters that I had to attend to. This was Mr. Hillier's case along with Ms. Olguin. The state represented to the court that it would be a 3 or 4 day trial. Mr. Hillier repeatedly tried to tell the court that it would not. Mr. Hillier repeatedly asked for continuances based upon this vacation. Mr. Hillier put in a vacation letter and told the court that if it went longer than last week, then it would run into his vacation.
And a vacation letter does not a motion for continuance make. And this was the date that was chosen by the parties. This case had been reset before because counsel said he had a CLE to attend. So the court gave him time to attend his CLE, and this is the date that both parties chose.
And the court
And he's in
represent,
the middle of a trial. And then we go back to the question is, if you're going to be his attorney, why were you not here during any parts of this trial? This is the first time that you've appeared to sit. And if Mr. Hilliard knew he was not going to be here, why did he not have you qualified before the jury? It would have been a simple matter of his asking the jury, oh, we're going to have Jason Goss who may come sit with us. Does anybody know Jason Goss?
Mr. Hilliard believed based upon when the court set this case, if the court remembers, the court set it for last Monday. The court decided not to go to trial last Monday. If the
Because
court
he said that he had a CLE to attend where he was seeking to obtain his board certification.
No, Your Honor, the week before. That was the week before. Last Monday was when this trial started. The court told the parties that they would start on Monday and be here Monday. The court decided not to start until Tuesday. Had the court started on Monday, Mr. Hilliard would have been here today. I mean, the case would have been over on Friday.
Mr. Hilliard had a choice to make. He chose to go on his vacation.
Your Honor, the reason that there are vacation letters is because the courts have recognized that it is not a choice when somebody has a family, when they have non-refundable tickets, when they have plans that have been made for over a year's time. In addition to, he is not in a position where he could join them late because they are on a ship in the middle of the ocean. So he is not in a position that he could leave his family.
So you're telling me that cruises do not dock in different places?
They perhaps dock in different places, but he could not make half of the vacation with his family and was not willing to have his family go along without him. And that is why there are vacation letters. So the defense is asking for a continuance to allow Mr. Hilliard back.
Oh, that's going to be denied.
I understand. And additionally,
And have you filed a motion for continuance?
defense is asking for a continuance from the court at this time based upon these
So
circumstances.
you have not filed a motion for continuance, is that correct?
We will file a motion for
No,
continuance.
my question is, have you filed a motion for continuance?
The motion for continuance was filed before and it was denied. And
Have you filed a motion for continuance? We're in the middle of a trial. Have you filed a motion for continuance now?
we have not, we will,
That will be denied.
yes, Your Honor.
All right, so the issue is whether or not, state, do you object to this council being present?
Yes, Your Honor, the state objects.
And as I argued before, they do not have the right to have a question about whether somebody on the jury might recognize me or look at me and know who I am. That right does not supersede my client's right to counsel of his choice and to effective representation of counsel.
Well, the counsel he chose was obviously Mr. Hilliard because he was here, Ms. O'Gean was here. So those are the two counsels he chose from your firm. And again, we're back to the point. Why did you not appear for any stage of this trial before now?
Because the court and the state represented that the case would be done last week, and it was not. So based upon those representations made by the state, 3 or 4 days, which is on video and on the record, in the court, who believed that it would be done last week, I had other settings that I had to go and appear at. And so
Other settings that were jury trials?
other settings that were potential jury trials that didn't turn out to be jury
So
trials.
not jury trials.
Not jury trials, Your Honor. However, in this situation, the state objecting in this situation to me sitting and assisting Ms. Olguin is that right is so low on the totem pole compared to his right to allow me to sit here and assist Ms. Olguin.
So hypothetically, let's say somebody from the state's office were to come down to sit there and they haven't been qualified before the jury.
Right.
And you say, oh, that's fine. And then we discover, oh, their mom is on the jury. That
Right.
would be fine with you.
Well, I know my mother's not on this.
No, that's I'm giving you a hypothetical.
State does not have a constitutional right to counsel.
I'm giving you a
State
hypothetical.
does not have a Sixth Amendment right to
So
counsel.
let me ask you this. So let's assume your mom is on this jury. Do you think that you should still be allowed to sit? Let's assume one of your best friends is on the jury. Do you think that would be a fair trial for the state for you to sit?
I think.
Yes
that-
or no?
I think that their issue with that would not outweigh his Sixth Amendment right. It's a
Okay.
constitutional right versus the state's disagreement or some possibility that does not exist.
Mhm.
So no, my mother and my best friend are not on this jury.
Well, you wouldn't know that.
Well, so I would definitely know if my mother was,
Mhm.
right? So, and she's not, because I know where she is and she's not serving on this jury. As far as the other balance, it's just a balance of rights. I mean, I am here, I am willing to assist Miss Olguin. It is important for my client's rights and his Sixth Amendment right to allow me to do that.
All right, are the jurors present? All right, let's line them up. All right, ladies and gentlemen, I have a few questions to ask of you. Mr. Hilliard is not present. As you can see, he's not present in the courtroom. The person who's now at this table is an attorney by the name of Jason Goss. Please stand. You may be seated. Does anyone recognize or know the attorney Jason Goss? If you do, please raise your hand. All right, so that the record is clear, no one has raised their hand. State, do you have any questions with regards to that matter?
I know, Your Honor.
All right, thank you. All right, with that being done, can I have attorney's approach? All right, state where we left off. We were still in your case in chief. Call your next witness.
Your Honor, at this time, state rests.
All right, defense, do you have any witnesses?
Your Honor, we do. We'd like to be heard outside the presence of the jury on a motion.
All right, so ladies and gentlemen, if you'll just step in the hallway for 2 minutes and then we'll bring you back in. All right, everyone, please be seated. All right, and defense, you have a motion outside the presence of the jury?
Yes, Your Honor. Even looking at in the light most favorable to the non-moving party, that is the state, we would ask for a directed verdict on the manner and means, number 7, which is operating a motor vehicle while impaired by reason of the introduction of alcohol into the body. Your Honor, there has not even been a scintilla of evidence that Mr. Castro was impaired. The only evidence that the state has produced is that he admitted to drinking 4 to 5 beers about 8 hours before this accident happened, which was around 6 p.m. There has been no further testimony about anything regarding alcohol. The only other thing could be Detective Martinez saying that she smelled alcohol on his breath, which later, after we impeached her, she said that she had actually told her supervisor that no, she did not smell alcohol on his
All right,
breath.
just one moment,
Yes, Your Honor.
just one moment.
Yes.
All right, sorry about that.
Oh, I'm sorry, Ms. Olguin just went to check on our witness who
Sure.
just got here.
All right, you may proceed.
Do you want me to repeat what I said, Judge?
No, I remember you have the issue with the operating a motor vehicle while impaired by reason of the introduction of alcohol into the body?
Yes, exactly, Judge. So there has not even been a scintilla of evidence that has been provided by the state about even what impairment means, or if Mr. Castro had any of those signs or exhibited anything that any of the officers, I think they had 4 or 5 officers testified that interacted with him. None of them explained that he exhibited any of these signs. No slurring, no swaying, no grabbing onto any items. Absolutely nothing was testified to about Mr. Castro being impaired by the reason of alcohol. So for that reason, Your Honor, we'd ask for a directed verdict on that manner and means, because also additionally, the prejudicial effect would substantially outweigh any probative value on this.
All right. And that is the only manner and means that you're objecting to?
That, Your Honor, and just also the entire indictment, because there has not been any testimony that Mr. Castro was actually aware of the risks that were ahead and that he consciously disregarded them.
All right. State, do you want to address the manner and means impaired by reason of the introduction of alcohol into the body?
Yes, Judge. So there has been testimony from Detective Horta, who did testify that he did conduct HGN on the defendant. He testified that there were 2 of the 6 signs and that those 2 signs indicated that at some point the defendant was drinking. There was also testimony from Sergeant Doyle, who, when defense asked what reasons someone could drive 90 miles per hour into the back of somebody's car, Sergeant Doyle on redirect was able to say that one of the biggest reasons why any of these accidents happen is due to the fact that someone may be intoxicated. Again, that's more than a scintilla. That's enough for the jury to make a determination as to whether or not impairment could have caused or helped play a role in this case. So that's why the state would ask that motion for directed verdict on that part be denied.
All right, defense, it's your motion. I'll allow you for final argument.
Your Honor, Detective Orta saying that there was 2 out of 6 clues of the HGN alone does not come back to any sort of impairment. It just goes back to the consumption, which is number 6 of the manner and means, which is what Mr. Castro admitted to. For number 7 to exist would be the jury having to make a crazy leap. And there's not been any sort of evidence to explain to them what impairment means or even that he had those signs. And then Detective Doyle saying that these accidents happen around this time because of intoxication. Again, Judge, does not lead back to Mr. Castro and doesn't explain what impairment means. Also, Your Honor, Mr. Hillier on cross-examination established that the HGN needs 4 clues to show loss of normal physical or mental faculties. And Detective Orta testified that he didn't even have the 4 clues to go on to the next 2 SFSTs.
All right, motion will be denied. State has rested. Defense, do you have witnesses you will present?
Yes,
Yes, Your Honor.
All right, you want to have your witness come in and take the stand?
Can I just have 3 minutes with her? We did have to
Yes.
subpoena her.
Yes.
Thank you, Judge.
No, thank you. All right, thank you. All right, Maria, if you'll grab the exhibits. Mhm. All right. Defense, are you ready to proceed?
We have a brief moment to confirm.
Your Honor, I'm sorry, may we have 10 minutes with this witness? We had to subpoena her and she just finished maternity leave yesterday. So it was not possible for us to openly communicate with her.
All right, I'll give you 10 minutes. Any objection to the court speaking to the jurors and just letting them know that we'll be back in 10 minutes?
No objection from defense, Judge.
No, Your Honor.
All right. Yes.
All right, for the jury?
Yes. Right, everyone, please be seated. All right, the state has rested. Defense, do you have any witnesses?
Yes, Your Honor, we call Officer Lechuga.
All right, can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up so that everyone can hear. If you'll state your name for the record and spell it.
Destiny Lechuga, Destiny, last name Lechuga, Lechuga.
Defense, you may proceed.
Yes, Your Honor. Good morning, Officer Lechuga.
Good morning.
So I'm sure the jury's wondering why you're not in your uniform. We've seen all the other officers in their uniform. Can you explain to them why that is?
Right now I'm on light duty, so I'm at the academy, not performing normal patrol functions. I'm just helping with TCO licensing and stuff like that. I'm can't perform my normal duties as a police officer right now.
Why can't you perform your normal duties?
Because I'm on FMLA leave, or I was on FMLA leave. I just had a baby, but now I'll be back on patrol in 2 weeks.
Congratulations on your baby. So once you've recovered, you'll be able to get back, like you said, on patrol in those 2 weeks.
Yes, ma'am.
And then you'll be able to be on your normal regular schedule.
Yes, ma'am.
Officer, we heard from Officer Morgan. He was one of the first officers on scene for the initial crash. What was your role on July 22nd, 2022 in regards to that first crash?
I was a cover officer, so I was just doing whatever Officer Morgan needed to secure the scene.
And as a cover officer, what was your role with the driver of that first accident, Shayna Lassell?
As my cover, or as his cover officer, I was just trying to eliminate traffic. But the two vehicles were blocking both traffic or both lanes, so I was just trying to provide an open lane by pushing a vehicle out.
When you arrived, what did the scene look like with that first accident?
Traffic had been backed up all the way to the on-ramp of the exit ramp. So our vehicles were the last vehicles that were at the end of the traffic. We walked about, I don't even know how long. There was about 60 cars to this first accident. When we got there, one vehicle was facing the wrong way, the other vehicle was hit. It had passenger side damage. And the two drivers were out of the vehicle, just saying they had been in a car accident.
What did that accident look like?
Just a major accident. Airbags had been deployed. And that's about it.
Was it a head-on collision?
Yes. Like I said, the damage of the first accident, or the first vehicle had damage on the front, and the second vehicle had damage on the right passenger side.
And did you speak to both of those drivers from the first accident?
I can't remember if I spoke to the second driver, but I know I spoke to one driver.
And what was her name?
Sheila. I don't remember her last name.
Shayna Lassell?
Yes, ma'am. Shayna, I'm sorry.
And what did Miss Lassell tell you about the accident?
I'm gonna object to hearsay.
Sustained.
Your Honor, may I respond?
Yes.
Your Honor, we're not using it for the truth of the matter. May I approach?
No, I mean, you can respond.
Okay, we're not using it to prove the truth of the matter. What Shayna Lassell said is that she got an argument with her husband, and so she
All right.
started.
Sorry. All right, the objection will be sustained.
Yes, Your Honor. You spoke to Miss Lassell. The things that she told you, did it make sense to you as an officer?
Yes, she told me she had just been
I'm
in
gonna
a.
object to hearsay.
Sustained. You're not allowed to say what anyone else told you. Do you understand?
Yes, ma'am.
All right.
She was explaining to you why she was driving on the wrong way of the road.
Yes, ma'am.
And from there, you continue your investigation.
Yes.
And you were the one that primarily was in charge of Miss Lassell throughout that night.
After Officer Morgan had responded to the second accident, yes.
Okay, I want to talk about kind of what you observed when you were watching Miss Lassel for that hour or so. Your Honor, may I create a demonstrative to reflect this witness's testimony?
State,
I'm gonna object, Judge. I don't know what demonstrative.
well, let's see what the demonstrative is. And then state, you can raise your objections at that time. The
Yes, Judge.
court is not aware of what demonstrative she's making.
Your Honor, I'm just gonna write down her testimony about the description of Miss Lassel that night.
All right, then the state's objection will be sustained.
Okay, so let's talk about the signs of impairment that Miss Lassel showed that night. Was her speech slurred?
I'm gonna object to relevance.
Your Honor,
Ladies and gentlemen, if you'll step out in the hallway just briefly. All right, everyone, please be seated. All right, what's the relevance?
Your Honor, this goes directly to our defensive theory that Miss Shayna Lassel was a concurrent causation to this accident. This goes from the very beginning of our case of trying to establish that with the jury. And this officer is able to provide that light of the signs that Miss Lassel showed so that they can. It's already been testified, Judge, that the officers did not correctly control the traffic in this case. We're trying to establish what happened before that. And it goes to, did Mr. Castro actually cause the death? We believe that Miss Lassel was a concurrent cause to this.
State,
Judge, Ms. Lassel isn't on trial here. What she did or what observations the officer had about her aren't relevant to what Mr. Castro did. Again, the theory that they're trying to say is that it was concurrent cause, but no one had died out on that road until Mr. Castro came along. So no one else caused the death of the victim except for Mr. Castro. So again, we're objecting to relevance.
Judge, may I briefly respond?
yes, but just one moment. So with regards to relevance, the court is gonna sustain the objection as it relates to whether or not this prior accident, whether or not that person was intoxicated or what the cause of it was. But as far as that there was an accident and that this, I'm sorry, what is her name?
Shayna Lassel.
You can question the officer about the fact that there was an accident, that Shayna Lassel was involved in this accident, and if it was a head-on collision or whatever the circumstances, that it was a head-on collision or however. All right, so this witness can testify to the fact that there was an accident involving this other person. She can testify to the fact if it was a head-on collision, but the court is sustaining the state's objection insofar as whether the other person was intoxicated or what the circumstances that caused the accident. But you are allowed to question this witness that there was an accident, it was involving this other person. And if it was a head-on collision, you are allowed to question her about that. But as far as the defense believing that this other person was intoxicated, the court is going to sustain the objection to relevance, the state's relevance as a part to that testimony.
So just so it's my understanding, we will not be able to get into our defensive theory of this case of concurrent causation.
How is the fact that you think, or this officer thinks, that the first accident was caused by someone is intoxicated? How is the fact that the person was intoxicated, how is that interfering with your defense?
It goes to reckless behavior of Miss Lassel and then the reckless behavior of the police, which set up this entire scene, which goes to the jury deciding if Mr. Castro was actually the cause of death or if these two other concurrent causations were the ones that actually caused it.
All right, so here's the court's ruling. And I want to be clear and hopefully everybody understands me. You are allowed to question this witness that there was an accident. And for purposes of the record, I'm just going to call it accident number one.
Yes, Judge.
You can ask her about accident number one. You can ask her, where were the cars positioned, however you want to ask that. However, the reason for the accident that you think accident number one was caused by somebody who was intoxicated, the court is sustaining the state's objection to relevance as to that portion. Do you understand?
Yes, Your Honor. May I make a bill of exception?
Sure.
Do you want me to do that right now?
You can either do it now or you can do it after you completed your questioning of the witness. Mr. Goss, we're not in mock trial. If you want to say something on the record, you're more than welcome to say something on the record.
Yes, Your Honor. I didn't want to, yes, Your Honor. So we would like to ask her these questions and it just additionally, just so the record is clear, I understand the court's ruling. So the record is clear, the intoxication is reckless per se under the code. The fact that Ms. Alassal was intoxicated would make her criminally responsible for the things that happened afterwards. The way the court's ruling has, the court has limited us to here is that we cannot show that Ms. Alassal held criminal responsibility and was the criminal cause of the accident, which ended up in the death of the complainant in this case. And so we wanted to make that clear for the record. And then I guess if we can ask her the questions outside the presence of the jury, so they'll be preserved for the appellate court.
Yes. All right. So do you understand the court's ruling?
Yes, Judge.
All right, let's bring the jurors back in, please.
All right, for jury.
All right, everyone, please be seated. All right, defense.
Officer Lechuga, after dealing with this first accident, did you later find out that there was a second accident?
I'm sorry?
After you were handling the first accident with Shayna Lassel, did you later find out that there was a second accident?
It was during the time I was handling the first accident that I heard the collision of a second accident.
And who did you believe was involved in that second accident initially?
Officer Morgan, because our vehicles were the last vehicles that had stopped traffic onto the on-ramp.
And when you finally made your way to Officer Morgan's car to check on him, did you then find out that a long line had formed after his vehicle?
I never saw anything past our vehicles. I never went back there.
And you believed that the second accident was caused because of the first
I'm
one?
gonna object calls for legal conclusions.
Sustained.
Based on your experience and observations that night, you believed that the accident was caused because of Shayna Lassel.
I'm gonna object to legal conclusions.
Sustained.
What was your belief about the second accident?
I'm again gonna object to legal conclusions.
Sustained.
Would the second accident have occurred if traffic was not backed up because of Miss Lassel's accident?
I'm gonna object to legal conclusions.
Sustained.
Judge, this goes directly to her personal knowledge.
All right, sustained.
Officer Lechuga, later that night, you went and dropped off Shayna Lassel with her husband.
I'm gonna object to relevance.
Overruled. You can answer.
I took her off the highway and took her to a parking lot where we met her husband and she was given a ticket and released to her husband.
No further questions, Your Honor. We pass the witness.
Another from the state.
All right, is this witness excused?
Yes, from the state judge.
Yes, Your Honor.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state of the defense. Do you understand?
Yes, ma'am.
All right, and if you'll remain in the back room.
Yes, ma'am.
All right, thank you. Defense, call your next witness.
Your Honor, may we approach?
Yes. All right, defense, call your next witness.
Your Honor, defense rest.
State,
State rests.
close.
Yes, ma'am. Well, state closes.
Defense, you close.
Yes, Judge.
All right, ladies and gentlemen, you've heard all the evidence that you're going to hear in this case for this phase of the trial. I'm going to have y'all step to the back and we will bring you out. I'm estimating maybe 10:30 or 10:45 at the latest. And at that time, both parties will have a chance to submit to you their closing arguments if they choose to do so. All right, everyone, please rise for the jurors. And does anyone need to see if the equipment is working, if anyone's going to use a PowerPoint for their closing?
I'm using a PowerPoint, Judge.
We just need to, whenever you want.
So y'all probably want to make sure that the equipment is working.
Yes, Judge. I will check it right now.
It's been a little bit spotty today.
So,
Yeah, it's on. Yeah, there we go.
Okay.
check to see, I think it's working.
All right, we're going to go on the record. Defense has filed a motion for continuance. State, have you had a chance to review defense's motion for continuance?
Yes, we received it from defense, Your Honor.
Okay.
Oh, yes, we did have a chance to review it.
All right, state, do you have objections?
Yes, Your Honor.
All right, defense. Court will hear your argument.
Yes, Your Honor, it is basically the argument that I had made before. Mr. Hillier, when the court allowed for the continuance for the CLE, in that same motion for continuance, it did list that Mr. Hillier would be out from these dates. At the time, the court had stated that they would start on Monday. State represented to the court that this case would last 3 to 4 days. Mr. Hillier represented the court that it would last 5. The understanding, Mr. Hillier's understanding and our understanding was that the trial would begin Monday of last week. It did not in fact begin jury selection until Tuesday, which would put this as the 5th day of trial, which would have been Friday. Mr. Hillier was not in a position where he could not leave the country as previously stated to the court. We've also attached the vacation letter, which I understand is not a motion for continuance, but it does show that Mr. Hillier has made the county, Bear County, aware of this vacation from before this setting was done. And in short, the defendant is entitled to counsel of his choice, effective defense of counsel under the 6th Amendment. As the court has seen, Mr. Hillier was very prepared in this case. He has been the first chair of this case, trying this case. And so we are asking that the cause be continued until Mr. Hillier can return in order to give the client the benefit of Mr. Hillier's ability to argue to a jury that he has formed a relationship with, that he has presented this case in front of. And denying that, we would say denies the client the 6th Amendment right to counsel of his choice, 6th Amendment right to effective counsel. And so we're asking for that continuance.
All right, so are you stating that Mr. Castro has not formed a relationship with you or all individuals in the firm?
Sorry, what, Judge?
So are you saying that Mr. Castro has not formed a relationship with you or all the members of the firm?
I am saying that Mr. Castro, I have met him, but Mr. Castro has understood from the beginning that Mr. Hillier, who has just come off of trying 2 different intoxication manslaughter trials, Mr. Hillier would be the primary attorney responsible for his case.
All right, and Ms. O'Gean has been here throughout the entirety of this trial?
Yes, Your Honor.
State?
Yes, Your Honor. Response to defense counsel's motion for continuance. 1, defense counsel was made well aware of when this case was reset to because of the CLE. He agreed that this would be reset to that day when we started trial. So he was given an opportunity to object at that time. He did not object, brought up the fact that he was going on vacation, but felt inclined to agree to the reset date of 1 week so he can attend the CLE. So he was well aware of the time constraints that he was under. So he didn't take his due diligence there, and he chose to actually agree to this date. Also, this is the 3rd or 4th, at least, motion for continuance by defense, and other continuances have all been granted. And the relationship, as defense counsel brought up, is that they have there's a law firm of several attorneys that are associated with that firm that obviously know about this case and aware of this case, was aware of Mr. Hiller's vacation letter, aware of the CLE. So in light of that, Your Honor, the state would be objecting to the motion for continuance at this time, believe that the jury would be, the fact finders would be held at an inconvenience, not only an inconvenience, but also an irreparable harm done by forgetting evidence and things of that nature, Your Honor.
All right, the motion for continuance is denied. And Ms. Ferguson, I sent you an email, so if you can make new copies. And Ms. O'Gean, with regards to closing arguments, did you want a warning?
Yes, Judge, just a 5-minute warning and a 1-minute warning,
Sure.
please. Thank you.
You're welcome.
I'm gonna check the technology.
Thank you.
Excuse for 2 minutes.
Yes.
We're great.
Yeah, sure.
Is it not? That's why I was like, check beforehand, because you never know.
It's not me, Judge. I don't know.
Okay, I think it is gonna work.
Sure.
Mhm. All right.
Daniel will come back. Okay, good work.
Well, Sean, it's like the episode from Star Trek, Day of the Gun, where Mr. Spock was saying, according to the laws of physics, it should work, but it's not working. So he said, logically, the laws of physics don't work here.
They're gonna do it.
All right, have both parties had a chance to review the
Yes, Your Honor.
charge? State, do you have any objections?
Judge, just one portion. One portion where on page 1, 2, 3, where the bullet points, and the last bullet point says by operating a motor vehicle after consuming alcohol. and then it's an and.
Yes.
We believe that should be another bullet point at that point, because in our indictment, the way it's indicted, it has that separated.
All right, defense?
Well, Your Honor, obviously we maintain our objection that the impaired has not been defined and it has not been proven. Um, the
So other than that, with regards to it being another bullet point,
well, the reason that they put it is the same is because it's not unlawful to operate a motor vehicle after consuming alcohol, and that standing alone cannot be the basis of recklessness.
so my question is, do you have any objection to it being a separate bullet point?
Yes, based upon that, what I just argued to the court.
Judge, if I may,
Yes.
I mean, you even do his argument just now, with the objection about, in the indictment, it reads, operating a motor vehicle after consuming alcohol. And then, comma, then it would go into operating a motor vehicle while impaired by reason of an introduction of alcohol into the body. So the way it was indicted is definitely two separate statements.
And our argument is the way it's indicted is not sufficient. It
Well, nobody objected to the indictment.
well, I guess based upon the evidence that they've proven, the way that it's indicted, I believe Mr. Hillier did object to the introduction of alcohol.
No, he never objected to the indictment. There were no objections made to the indictment. So the indictment is the indictment.
Well, as it may be, then our argument here is that by separating those two out, it would seem to suggest that introduction of alcohol in the body is by itself without causing impairment is a reckless act, which it is not.
All right. Any other objections?
I'm sorry, Judge.
Any other objections from the state?
No, Your Honor.
All right, defense, any objections?
Yes, Your Honor, defense is requesting the lesser included charge of criminally negligent homicide, which has not been included in this charge. The evidence is sufficient. When looking at the light most favorable to the defense and based upon the standard required for us to get a lesser included charge, the evidence is sufficient based upon the officer's testimony, the expert's testimony of the crash math and the mechanics of the crash, that there was not any braking, and there was testimony that it appeared as if the person was not aware that there was an accident that was in front of them. If they were not actually aware of the circumstances, then it would not be reckless. Criminal negligence requires that they should have been aware, which we believe the jury could find. And there is enough evidence in the record to find that the defendant is not guilty of reckless manslaughter, but is guilty of and only guilty of the offense of criminally negligent homicide, which is required by the law that deals with lesser included, particularly Hall versus State. But our argument is that there is enough in the record that the defendant was not aware of the circumstances as they existed at the time, so therefore did not consciously disregard a risk he was aware of. There could be evidence, and there was evidence that he should have been aware based upon the signs, based upon the lights, based upon other things, that he should have been aware of those things. And so therefore we are asking for the lesser included of criminally negligent homicide to be included as part of the court's charge.
State?
Judge, at this time, the state's position is that there's no evidence that this defendant wasn't aware of any statements made by this defendant, and evidence that came in that he was aware of the substantial risk and unjustifiable risk.
All right. All right, any other objections to the charge?
None other than the objections that we've already made.
All right. So with regards to, have a seat.
Thank you.
With regards to the defense's, I'm sorry, with regards to the state's objection, requesting that the bullet points by operating a motor vehicle after consuming alcohol, and by operating a motor vehicle while impaired by reason of the introduction of alcohol into the body. That objection will be overruled. It will stay in the charge as submitted. With regards to the lesser included offense, the lesser included offense will be included in the charge. Is there anything else?
Nothing to state. Your Honor.
Nothing from the defense, Judge.
All right, so the charge will be here shortly, and then you each will have 25 minutes to argue. You can line them up.
Your Honor, may we approach?
Pardon?
The language is.
What is incorrect? Approach. All right, ladies and gentlemen, I'm going to read to you what's called the charge of the court. You do not have to memorize it because you will receive it when you begin your deliberations. Members of the jury, the defendant Alex Castro stands charged by indictment with the offense of manslaughter alleged to have been committed on or about the 22nd day of July 2022 in Bear County, Texas. To this charge, the defendant has pled not guilty. 1, our law provides that a person commits the offense of manslaughter if the person recklessly causes the death of an individual. 2, individual means a human being who is alive. 3, a person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards of substantial and unjustifiable risks that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4, a person is criminally responsible if the result would not have occurred but for his conduct operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. Therefore, you cannot find the defendant, Alex Castro, guilty unless you believe beyond a reasonable doubt that the death of Alexandra Sabert would not have occurred but for the conduct of Alexander Castro, so that if you believe that another cause or other causes, to wit, the conduct of Shayna Alasso and or the conduct of police officers by failing to put out flags and or flares to prevent an accident was a concurrent cause or were concurrent causes sufficient to cause the death of Alexandra Siebert, and the conduct of the defendant, Alexander Castro, was clearly insufficient, or if you have a reasonable doubt thereof, you will acquit the defendant, Alexander Castro, and say by your verdict, not guilty. 5, now if you find from the evidence beyond a reasonable doubt that on or about the 22nd day of July 2022 in Bear County, Texas, the defendant, Alexander Castro, did recklessly cause the death of an individual, namely Alexandra Sabert, by driving or operating a motor vehicle at a speed that was not reasonable or prudent under the circumstances then existing, and or by failing to keep a proper lookout, and or by failing to apply the brakes in a timely manner, and or by failing to take proper and necessary evasive action to avoid colliding with another motor vehicle, and or by failing to maintain a proper following distance, and or by operating a motor vehicle after consuming alcohol, and by operating a motor vehicle while impaired by reason of the introduction of alcohol into the body, and said acts and or omissions resulted in the motor vehicle being driven and operated by Alexander Castro colliding into the motor vehicle occupied by Alexandra Sabert, and that result would not have occurred but for the conduct of Alexander Castro as instructed in paragraph 4, then you will find the defendant, Alexander Castro, guilty of the offense of manslaughter as charged in the indictment, and do not consider paragraph 6 and 7. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of manslaughter as charged in the indictment, say by your verdict not guilty of manslaughter, and next consider whether the defendant is guilty of the lesser included offense of criminally negligent homicide. 6, our law provides that a person commits the offense of criminally negligent homicide if he causes the death of an individual by criminal negligence. A person acts with criminal negligence or is criminally negligent with respect to circumstances surrounding his conduct or the result of his conduct when he ought to be aware of substantial and unjustifiable risks that the circumstances exist or the result will occur. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances and viewed from the standpoint of the person so acting. 7, now if you find from the evidence beyond a reasonable doubt that on or about the 22nd day of July 2022, in Bear County, Texas, the defendant, Alexander Castro, did with criminal negligence cause the death of an individual, namely Alexandra Sabert, by driving or operating a motor vehicle at a speed that was not reasonable or prudent under the circumstances then existing, and or by failing to keep a proper lookout, and or by failing to apply the brakes in a timely manner, and or by failing to take proper and necessary evasive action to avoid colliding with another motor vehicle, and or by failing to maintain a proper following distance, and or by operating a motor vehicle after consuming alcohol, and by operating a motor vehicle while impaired by reason of the introduction of alcohol into the body, and said acts and or admissions resulted in the motor vehicle being driven and operated by Alexander Castro, colliding into the motor vehicle occupied by Alexandra Sabert, and that result would not have occurred but for the conduct of Alexander Castro as instructed in paragraph 4, then you will find the defendant, Alexander Castro, guilty of the lesser included offense of criminally negligent homicide. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Alexander Castro, not guilty of the lesser included offense of criminally negligent homicide. 8. If you have found the defendant, Alexander Castro, guilty of the offense of manslaughter as charged in the indictment, or guilty of the lesser included offense of criminally negligent homicide, you are instructed to make a separate finding as to whether the defendant used or exhibited a deadly weapon, to wit, a motor vehicle, during the commission of the offense for which you have found him guilty. If you have found the defendant not guilty of both manslaughter and criminally negligent homicide, do not consider this paragraph and do not make a separate finding. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Therefore, if you find the defendant, Alexander Castro, guilty of the offense of manslaughter as charged in the indictment, or guilty of the lesser included offense of criminally negligent homicide, and if you find from the evidence beyond a reasonable doubt that Alexander Castro did use or exhibit a deadly weapon, to wit, a motor vehicle, that in the manner of its use or intended use was capable of causing death or serious bodily injury during the commission of the offense for which you have found him guilty, then you will so state in your verdict. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will so state in your verdict. 9, you are instructed that under our law that no evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or the Constitution or laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. Therefore, if you believe or have a reasonable doubt that the evidence was obtained in violation of any provisions of the Constitution or laws of the United States or the state of Texas or of the Constitution or laws of the United States, in such event, the jury shall disregard any such evidence so obtained. You are instructed that a person is considered in custody only if, based upon the objective circumstances, a reasonable person would believe he was restrained to the degree associated with a formal arrest. Custodial interrogation is defined as questioning initiated by someone in the role of a law enforcement officer after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. Custodial interrogation exists when a reasonable person would have believed he was not free to terminate the interview and leave. In determining whether a person is free to leave, the following factors are considered. 1, whether probable cause to detain the person existed at the time of questioning. Probable cause exists when facts and circumstances within an officer's knowledge and about which he has reasonable, trustworthy information are sufficient to warrant a person of reasonable caution to believe that an offense was or is being committed. 2, the subjective intent of the officer or functional equivalent of a law enforcement officer during the questioning. 3, the focus of the investigation. And 4, the subjective belief of the individual being questioned. If you find that the defendant made a statement while in custody of an officer and under interrogation, before that statement may be considered voluntary, it must be shown beyond a reasonable doubt that prior to making such oral statement to an officer, that the accused defendant had been warned by the person to whom the statement is made that one, he has the right to remain silent and not make any statement. Two, that anything said by the defendant will be used against him at trial. Three, that the statement will be used against him in court. Four, that he has the right to terminate questioning at any time during the interview or questioning. Five, that he is entitled to the services of an attorney, his or own, or if he is unable to employ one, a court-appointed attorney to advise him prior to and during any questioning or interrogation. You are also instructed that a statement of a defendant made while he was in custody of an officer and while under interrogation may only be admissible in evidence if it appears that the same person was freely and voluntarily made without compulsion or persuasion. Before a statement made orally to officers may be considered voluntary, it must be shown that the accused knowingly, intelligently, and voluntarily waived the rights set out above. A defendant's statement may also be considered involuntarily. A defendant's statement may also be considered involuntary when there is police overreaching in the form of official, coercive conduct of such a nature that any statement obtained thereby was likely to have been the product of an essentially free and unconstrained choice by its maker. You are instructed that unless you believe from the evidence beyond a reasonable doubt that any statement introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you should not consider such statement for any purpose nor any evidence obtained as a result thereof. You are also instructed that any evidence seized as a result of voluntary consent to search is admissible against the accused at trial. However, if consent for the search is involuntarily given, any evidence obtained may not be used in the trial against the accused. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone any information or receive any information from anyone about this case or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charge beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
State reserves this time to make podium.
All right, defense?
Yes, Your Honor. This case is a tragedy. We told you from the very beginning that you would see things and you would hear things that would break your hearts. They've broken our hearts too. Miss Alexandra Saber's death is a tragedy. There's no doubt about that. And throughout this trial, you have seen what the pain of that loss has meant. You saw it when her boyfriend came up here and testified. It was hard. We felt those emotions and we saw all of that. But the law requires you to set those emotions aside and to look at the evidence. The law that you took an oath to requires you to look at the evidence and see if the state has proven their case beyond a reasonable doubt. The judge read to you that you are instructed to not let bias, prejudice, or sympathy play any part in your deliberations, no matter how hard that is for us as humans. That is the law. In this courtroom it is. And the reason being is because the state has the burden today. They have the burden to prove beyond a reasonable doubt that Alex was reckless and that he recklessly caused the death of Miss Sabert. And they have not met that burden. Because what reckless means is that you are aware of those circumstances and you consciously disregard them. You know it's in front of you and you let it go. You keep driving. Go. You know that you keep driving, even though that means you're about to commit suicide or you're about to seriously injure yourself, like we heard the detective say. Those are the only two options. That's what the state wants you to believe, that Alex was aware. And the state hasn't proven that Alex was aware that there were actually cars stopped in the road. The evidence has not shown that. Now, the question is, should Alex have been aware? And all their evidence points to is that Alex should have been aware. He ought to have been aware that there were cars up ahead. But there has been no evidence to establish that he actually knew what was going on. Gary, I want to briefly mention him. Gary has been here throughout this trial. He's been with us, with Alex, and he unfortunately had to go out of the country. He wanted to be here, and he wanted to finish this case last week, as we hoped it would, but we could not finish last week. Now, even though Gary isn't here at one of the most important parts of Alex's trial, we ask you not to hold that against him, because I'm here and I've been here with him and with you all throughout this trial. And I want to get into some of the things that Gary would have said if he were here. This case, when the state opened and talked about this case on Wednesday, they presented to you a case that just involved Alex crashing into Miss Sabert's car. They presented something that was straightforward and easy, that there were no issues at all. This case is not a case where he was driving wrong way on 281 and did a head-on collision. Because then, of course, he would have been aware of the cars coming in front of him. Of course. This case isn't where he's driving 91 miles per hour in a residential neighborhood and Miss Sabert's car is at a stop sign. Because then, of course, that's reckless. That's not what this case is. And I wouldn't be here before you guys today if that's what this case was about. This case is about the perfect storm. Whether we like it or not, that's what this case is about. The dominoes that Gary showed you from the beginning, the series of events that led up to this, the parts that all the different characters played for this to happen. But for Shayna Lassell driving the wrong way on 281, this accident wouldn't have occurred. But for her doing a head-on collision on 281 and causing cars to back up for miles, this accident wouldn't have occurred. And this isn't to throw the blame on someone else. We absolutely know that Alex is in some part responsible for this. This is not to distract you guys. This is not to confuse you guys. This is the facts. If Shayna Lassell didn't cause that accident, and if the officers would have done their job, then this wouldn't have happened. We know that Shayna Lassell, she was never charged for anything. We heard that she was given a ticket after she caused this and then taken to her husband. That's it. That's all we heard. She was going the wrong way on 281. She was, not Alex. And even though he was going 91 miles per hour, he was going the right way on a highway. We know that San Antonio Police Department arrived at 1:56 for the first accident. Second accident happened around 2:20 or so in the morning. That's 24 minutes. 24 minutes that we heard from Officer Morgan, who is an honest officer. He's a good guy. We know he was doing his best out there. We're not here to say he's completely to blame for this. Of course not. But should something have been done to warn people of this huge accident? Of course it should have. He himself told us that something should have been done to warn of the crash to approaching vehicles, because this provides notice to other drivers. There is a reason that the police department has a policy on what to do when accidents occur. It's because things like this have happened before. It's because they know that appropriate policies and procedures need to take place to warn drivers of what's going on, to avoid this from becoming anything larger. There were no flares at all. Now you'll see on the body cam in Coban, that's in evidence, later on after the fact, after this accident has occurred, that they do implement flares and they close down the highway as they should have from the beginning. They did not reposition their vehicles. There was no reflective vest on, and there was no road closure. We do know that they had their lights on, but there was also a large buildup of traffic after those police vehicles. Cars and cars and cars, it went on. Going back to the crash report, which you have in front of you, and you will have it in evidence, we know that the responsibilities of the officer is to provide warning of the crash to approaching vehicles. They have to do that. They have to warn us. That is their job in the community. If there is a wrong way driver, if there is this sort of accident and it's at night and it's hard to see, you need to warn other drivers. They need to use flares. That's what their policy says. Call in fire units, request additional officers for traffic or crowd control. Officer Morgan was busy with the first accident. You see it on body cam. He's writing the report when this happens. But he could have requested other officers. And he said that to us. He could have. But he didn't. He did not do any of that. And what does that mean? That means that Alex was not aware of the accident that was in front of him. He was not. We also heard some statements from Officer Morgan. Now, when you see the body cam again, you'll see Alex get out of the car and he says he's okay. He's confused. He doesn't know what just happened. We've heard testimony. He was airborne. His truck flipped. He was in a serious collision. And that's not to victimize him, not at all. That's just to show the state that he was in when he got out of that truck. He did not know what happened. He was not aware of what he hit. He said he thought he hit an 18-wheeler. He never even knew about Miss Sabert's car. Did not know about her. And we never heard from evidence at what point in time did he actually learn about her or her condition. All he knew was that there was an accident, it was serious, and he knew that he had to stay there. He cooperated the entire time. We didn't hear one piece of evidence that he didn't want to cooperate, that he didn't answer questions with the police. He did all of that. He did everything. He stayed for hours and hours and hours. He did not go to the hospital. He did not go to EMS. He stayed there, answered questions, cooperated. Because as you will hear, he said, I just want to know what happened. I want to know what happened. And later on, at some point, he does say that he believes that the Honda came under him. And he believes that the Honda was driving erratically. Now, we've heard testimony that there were cars going the wrong way. Now, Miss Sabert, she didn't do anything wrong. We know that. She did not. She was just there. But what other cars were going the wrong way? We've heard from multiple witnesses that it was chaotic. We don't know what Alex saw right before that. We don't know if it was the wrong way drivers coming at him. We just don't know. He doesn't know because he suffered from that collision.
10 minutes in.
Speed limit. Now, the state has the burden to prove that Alex was reckless, and they have 7 different manners and means in front of you. The first being that speed limit. He was not going the prudent and reasonable speed limit that he should have. That alone is not enough. They have to prove that he knew what the speed limit was and that he recklessly disregarded it anyways. It's not just enough to say he was going 91 miles per hour. That's it, case closed. He shouldn't have done that. That's not the way the law works. They have to prove that he knew that it was a speed limit and he disregarded it anyways. What the evidence really shows us, what the photo that Miss Saber took that night, is that right along before the accident even took place, there is a work zone sign that says 45 miles per hour. We know that the accident took place before this. We know that the accident took place after this sign here. That's what the evidence in front of you will show. Right here. That's the only evidence at this table that the state, who has the burden, has provided you. That the accident right after it happened was 45 miles per hour. The issue with that is we have not heard any testimony of what the speed limit was before then. We don't know. Was it 60? Was it 70? Was it 65? Was it 75? No evidence. They want you to believe that he wasn't going the speed limit at 45 miles per hour. That was not the speed limit where the accident happened. And that's an unanswered question. That's an unanswered question that they haven't provided you. They've had multiple detectives testify, and none of them said half a mile before this accident, the speed limit was listed as this. 1 mile before the accident, the speed limit was listed as this. Nothing. Nothing at all. They just want you to look at that and say, okay, he's going double over the speed limit. That's it. That's not the case here. And if you have unanswered questions, if you go back to that deliberation room and you were wondering what was really the speed limit when the crash happened, where the crash happened, they owe you an answer to that. They owe you that answer. Proper lookout is another manner of means. Now, there was a visibility issue. We heard that from Joshua Rodriguez. Joshua Rodriguez was the one where he had his wife call 911. He was the only person that kind of saw the accident happen. He was the only person that was behind. And he says that he saw Alex speed up in front of him and he heard the crash. He's an unbiased witness. He has no motive here. He's not coming from the government. What did he tell us? He said he could not even see what happened. Why? Because he could only see the roofs of the cars from his vantage point. That's all he could see. He could not see the police vehicle. He testified to that. And why is that? Well, he explained to us the highway, it curves, it goes up, and then it goes down. It's not straight and flat like the police want us to believe. Because this witness who was there that day behind the crash, he said that. He explained it to us. And if Joshua couldn't see what happened with the crash, then Alex couldn't see. He could not see that there was an accident in front of him. Leslie Salazar, she explained the chaos of the scene that night. She explained that there were cars that were reversing to try to get off the highway. They were impatient. They didn't want to stay there anymore. She called 911. And she told us she called 911 so they would know where to go because of the chaos of everything. Avoiding colliding with another vehicle, failing to brake, and proper following distance. Those are other manners and means. What we heard from Detective Doyle is that there was no evidence of braking. There was no evidence of swerving. There was no evidence of evasive action. What does that mean? What does that mean if somebody doesn't brake, swerve, take any sort of evasive action when they're going towards an accident scene, when they're going towards standstill traffic? It means they're not aware. It means they're not aware unless they want to kill someone else and kill themselves. And there's been no evidence that he was actually aware of it. Detective Doyle says, well, if somebody doesn't brake, doesn't take evasive action, doesn't do all those things, it could be one reason is that they're not paying attention. And if they're not paying attention, then that means they're not aware. They're doing something else. We know that no one who is aware of that risk would do such a thing. No one. It doesn't make any sense. You have to use your common sense and know that there's no way that Alex could have been aware because he would have done something to prevent that. Now, the question is, should he have been aware? He should have been aware. Of course he should have. Paul Martinez, he told us he didn't see police. He just saw lights. He saw cars turning around going the opposite way. He saw cars going wrong way. There's about 5 or 7 of them that just kept going off of the highway. Both sides. He's in his lane. He told us there's cars coming this way, one way, and there's cars coming this way as well. I saw it. That caused all of this. That all came together. And he himself told us he believed the accident was because of the wrong way drivers. He believed that, and he was there that night. Peter, he saw wrong way drivers as well. He saw Alex go in the air. And he also said something very important. Peter said there was a white car behind me. There was a white car behind me. Where is that white car? That means that there was a car in between Peter and Miss Sabert's vehicle. We don't know where that car is. We don't know if that's one of the cars that went the wrong way right before this accident happened. We just don't know. And that's a serious question. He said he probably turned around. This is not an intoxication manslaughter case. It's not. It wasn't charged as an intoxication manslaughter case. And we're asking you not to let the state make you believe or think that it's an intoxication manslaughter case, because there's been no evidence about that. There was so many officers on the scene, so many, and they could have brought you any one of them to say anything about this, and they didn't. None of the officers saw any signs. There was no signs of impairment. The only evidence that they have and they have presented to you was from Alex himself when he cooperated. And what Alex told the police is that I had 4 to 5 beers about 8 hours before this, around 6 p.m. when I was golfing. That's what he said. No witness testified to any signs. Their own experts said that he was not intoxicated. Officer Morgan, we asked him, he was the first officer, any signs of intoxication on Castro? No. There's 10 post-op clues. Did you notice anything? Slurred speech, wobbly, unsteady on feet? No, he did not. Detective Orta, their expert, he said Alex was not intoxicated. He's a specialist. He's trained to recognize certain clues. He performed the HGN on Alex, we know that. And he says that he saw 2 clues, but that wasn't enough, that he was not intoxicated. SAPD Detective Martinez. Detective Martinez, she told y'all that she smelled alcohol until Gary showed her video and reminded her that when she was there on scene that night, right then and there, she told her supervisor when he asked her, "Did you smell anything on Alex?" She said no. Of course she wants to say yes after the fact. Of course she wants to hold somebody responsible for what happened. That's understandable. But that night, she said no, she did not smell anything. She knew that the primary crash was Shayna Lassell. She told us that Officer Morgan should have called them to let them know that there was a wrong way driver, but they didn't. We know that Alex consented to search his vehicle. He did that. After hours and hours and hours of being there, he told Detective Martinez asked him, "Can I search your vehicle? Can I get the airbags? Can I see how fast you were going?" And he says yes. Even hours and hours of being held there, hours of being questioned, hours of knowing that he could not leave, that he was being detained, he still consented to that. This case is about an accident, a horrible accident. We heard that from the medical examiner who listed the manner of death in this case as an accident. Deadly weapon. Not true. It's not true that Alex intended to use his car as a deadly weapon. And we know that because he was not aware. This is not a case where somebody's just shooting in the middle of fireworks going on in the city where other people are around. Then of course you should be aware that there's people around you.
5
and
minutes.
Thank you, Judge. What comes up has to come down. You're aware of that. That's not this case here. He was not aware that this could happen. This is not a case where he was throwing a rock off the highway and he could have been aware that he would have killed somebody. He did not intend to use his vehicle to kill anybody because he was not even aware that somebody was there. When you go back there, hold the state to their burden. Hold them to proving beyond a reasonable doubt that Alex knew of Miss Sabert's car in front of him and continued to go 91 anyways. Continued knowing he would kill himself. And what that means beyond a reasonable doubt is that if you go back there and you think perhaps he knew, maybe he should have seen it, maybe. that's not guilty. If you go back there and you think it's probably likely that he knew and he did it anyways, that's not guilty. The burden is beyond a reasonable doubt because they have to prove to you that he was actually aware of it and continued to do it anyways. Officer Lechuga, the state, when they presented this, they just wanted to go on to this accident. They did not mention anything new about the first one and the details of that. We had to bring the other officer this morning that you heard from today, Officer Lechuga, and we brought her to testify about Shayna Lassell. And she told us Shayna Lassell went the wrong way, caused this accident, and I wrote her a ticket and dropped her off with her husband. That's it. That's how this story ends. But for Shayna Lassell causing that horrific accident, Miss Saber wouldn't have been standing in standstill traffic. She wouldn't have. She might have already been home. And but for the police not warning other drivers, not putting up flares, Alex would have been aware of what happened. He would have been aware that there was standstill traffic in front of him, but he wasn't. All their evidence points to is that he should have been aware. That's it. Not that he actually was, because it doesn't make sense for someone to do that. And we're asking that you find him not guilty of manslaughter because he was not aware of what happened. He could not have been aware that there was standstill traffic, and he would have not continued to drive at 91 miles per hour, knowing that there was a car in front of him. He would have not done that. We ask that you find him not guilty of manslaughter. And if you want to hold him criminally responsible for this, the only thing that the state has provided some evidence of is criminally negligent homicide. That's it. That he should have been aware. He should have been aware of what he was doing. But it's important to remember he was going 91 miles per hour on the highway at night when there's not usually a lot of cars. He wasn't going the wrong way. He wasn't in a residential area. It wasn't like that.
State?
We bear a heavy responsibility when we get behind the wheels of our cars. Each and every single one of us is aware of the fact that if we are irresponsible or if we are reckless or any of those things, that we can kill someone. That risk is inherent in driving a car. The defendant's actions were reckless that night. He knew exactly what the risk was of not hitting the brakes, of driving over 90 miles an hour, of not taking evasive action, of firing a missile into a crowd of people. You've heard evidence from almost every single witness who was there at that scene. They all said that they saw this traffic. You heard from Leslie. She had more than enough time to see the traffic and to take an earlier exit to avoid it. The witnesses who were stuck in the traffic, they all clearly saw that there was a traffic buildup. The brake lights you could see for miles. Even the victim knew that there was traffic. All of them stopped. No one else died that night except for Alexander Seibert. No one else killed someone except for Alexander Castro. What was the very first thing he said when he got out of that car? I saw brake lights and I tried to brake. He knew what he was supposed to do in that situation, and he failed to do it. He never once changed his story up at least the first 2 or 3 times he told Officer Morgan about saying, well, I didn't brake, or I didn't see it. Each and every single time was, I saw brake lights. We all agreed in voir dire, that's the universal sign of there's traffic, there's cars on the road. You need to slow down. But he didn't do it. And he tried to lie about it. There's no roadway evidence that he ever once touched those brakes. There's no roadway evidence that he ever once tried to turn the wheel. There is evidence that to the left of this traffic, there was a lane wide open for him to go into. And he could have slowed down at that point, but he decided not to. The defense has been arguing and saying, well, it would have to be suicidal in order for him to do something like that. Well, guess what happens when you do something that's so suicidal and you involve another person? Guess what? You're being reckless with the risk to that other person. The speed, 91 miles per hour, over 90. Confirmed by both the black box data and the math. Confirmed by what he did to those other cars. You saw that in person yourself. That's what 91 miles per hour into the back of a car does to the other car. It destroys it. It obliterates it. That, of course, is a deadly weapon in the manner of its use. Driving a car 91 miles into the back of someone else is using a deadly weapon against that person. His actions were reckless. He never once took any of the responsibility that night. I tried to hit the brake. I gave it all I got. You guys can't blame me. But then he took that extra step. He knew that the victim was injured. He told Officer Morgan, they told me about how she's doing. Once he knew about that, he changed his story to now she came into me. None of the evidence supports that. She was at almost a dead stop going to the right. He knew that she wasn't going to make it. And so there's that blip of someone else I could point the finger to and say it was them. At no point did he ever once say that there was that other cause other than her. He's blaming a little dead girl for his own actions. Because he knows what he was supposed to do. I hit the brakes and gave it all I got. Well, turns out he didn't. I tried to stop. I tried to avoid him. Didn't really do that either. Only one person that night killed someone else out on 281. Miss Lassel didn't put her foot on the pedal of that truck. Or SAPD wasn't behind the wheel. And she used to not evade. It's just him. Everyone would have been okay if not for his actions. The victim was still alive despite sitting in traffic. The accident had already happened and she was still alive. SAPD hadn't shut down that highway, and yet she was still alive. But it's when she crossed paths with him that she died. He's the cause of her death. Defense is bringing up criminally negligent homicide. That's what's called a lesser included offense. Less punishment.
Objection, Your Honor. That is improper argument.
Sustained.
Your Honor, we move for an instruction disregard.
All right, ladies and gentlemen, you're just to disregard counsel's last statement.
Your Honor, we move for mistrial.
Denied.
Criminally negligent homicide that he should have known. He knew. He knew exactly what he was doing and what his actions would cause. Do not hesitate for a second there. Everything has been to blame everyone but himself. It's SAPD, Miss Lassel, it's Miss Siebert, but not him. SAPD messed up their investigation. There are several things that Officer Morgan stated that he could have done, and he didn't. That's a lucky break for the defendant. He got the benefit of that. There were no direct witnesses who immediately came forward and said, this is what I saw. It's another lucky break. That's another benefit. at this point in time, the lucky breaks need to stop. There needs to be accountability here. There needs to be someone, again, jury of his peers who come in and say, enough is enough. To hold him accountable. To make sure that it is clear that this is not okay in our community. By saying not guilty or criminally negligent homicide, it's as if you're being asked to say, well, as long as SAPD doesn't set up flares, and as long as someone else causes that traffic buildup, slam into the back of someone going 90 miles per hour, that it's okay. Obviously, all of you know it's not. Because of the devastation it can cause to not just yourself, but the other people on that roadway. This was Alexander Siebert. She had just graduated from UTSA. Her life was only just about to start beginning. This is what the defendant did to her. This is what he caused by his actions. Doesn't even look like a car anymore. The conscious disregard, the safety of everyone else on that roadway. There's no evidence that he was sleepy. There's no evidence that he was distracted. There's no real evidence of anything other than the fact that his eyes were on that roadway. The state is asking you to find him guilty of manslaughter because that's what this is. It is the reckless disregard of the unjustifiable risk. The fact that someone would be willing to do this again, it's just shocking. State is asking that you find the defendant guilty of manslaughter. The state is asking that you find the deadly weapon allegation true. Because any vehicle going that fast, going into someone, deadly weapon, plain and simple. Anyone who says that they saw the brake lights and took no evasive action or no attempt to evade knew what they were doing. There's no highway in Texas that allows you to go up to 90 miles per hour.
Objection, Your Honor. Facts found in evidence.
Ladies and gentlemen, you'll remember that evidence as you received it.
We're
Your
asking
Honor,
you-
may I get a ruling?
Yes, overruled. You'll remember the evidence as you received it.
The state is asking you to find him guilty of manslaughter.
All right, ladies and gentlemen, Deputy Laura has you in her charge. Can you mute us, please? All right, everyone, please rise for the jury.